Section 5. All 20 defenses fail to meet the Woodfield requirement. Under Woodfield, affirmative defenses must provide fair notice so that plaintiff was not a victim of unfair surprise. Here, defendants assert 20 bare bones affirmative defenses consisting merely of legal conclusions without supporting factual allegations. All 20 defenses are fatally flawed for the following reasons. Each defense is pleaded as a bare legal conclusion without supporting factual allegations, merely naming legal theories without explaining their application. 5.4. The strategic incompatibility goes beyond mere pleading deficiencies to raise fundamental questions about whether these defenses can be asserted in good faith under Rule 11. Joint counsel cannot simultaneously believe acted according to policy necessary for his immunity defense and against policy necessary for the city's defense against Monell liability. This irreconcilable conflict explains why the defense lacks factual specificity, because any factual detail would necessarily hurt one client while helping the other. 5.5. This conflict-driven ambiguity makes fair notice impossible regardless of pleading detail. Even a more specific answer would remain fundamentally defective if it continued asserting incompatible defenses without specifying which defendant is asserting which defense. Only clear delineation of which defendant asserts each defense can provide the fair notice required by Woodfield. And Woodfield's a Fifth Circuit controlling case for defense pleading standards. Defendants engaged in impermissible shotgun pleading by asserting 20 defenses in conclusory fashion without factual development. This kitchen sink approach directly contravenes Woodfield's requirement that defenses contain sufficient factual matter to provide fair notice. The defenses provide no factual basis showing how they relate to plaintiff's specific constitutional claims, leaving plaintiff unable to meaningfully prepare for discovery. 5.9. Even under this district's more permissive approach, Woodfield still requires minimum factual development beyond mere recitation of legal doctrines, which defendants have failed to provide for any of their 20 asserted affirmative defenses. So that's the first 5 sections. We're on page 6 of the motion to strike. Section 6, insufficient, impertinent, prejudicial affirmative defenses. 6.1, first affirmative defense, failure to state a claim. Rule 12H2 provides that failure to state a claim upon which relief can be granted, a defense that may be raised at trial on the merits. However, this preservation rule doesn't transform a Rule 12B6 challenge into an affirmative defense subject to waiver under Rule 8C1. The proper procedural vehicle for failure to state a claim challenges is 12B6 motion, pre-answer, a 12C motion for judgment on the pleadings, post-pleadings, or 3, at trial pursuant to 12H2. According to defendants' attempt to characterize their challenge as an affirmative defense is procedurally improper and should be stricken without prejudice to their right to raise the issue through a proper Rule 12 channel. So I don't think they even raised that in their 12C.
What was that?
Failure to state a claim.
Not in their 12C, but they did come back in response to the motion to strike and said that this should have been raised as a 12C, but they couldn't articulate anything.
Right. So the 12B6 is pre-answer. And their 12C, which they did file after the motion to strike, was they argued statute of limitation, immunity, and no similar violations existed. But that's still an immunity defense. it wasn't well established. These violations of your rights weren't well established. 6.2, their third affirmative defense, standing. Standing is a constitutional requirement that goes to the court's subject matter jurisdiction under Article 3, not an affirmative defense. See worth. Unlike affirmative defenses, standing cannot be waived and may be raised at any time, including sua sponte by the court. A conclusory assertion that plaintiff lacks standing fails to meet Rule 8's notice pleading requirements. Defendants must specifically allege facts showing that elements of standing, injury in fact, causation, or redressability are lacking. The complaint alleges direct injuries to plaintiff with supporting exhibits. These allegations establish concrete, particularized injury directly traceable to defendant's conduct and redressability by a favorable decision. And see a quote from Lujan. So we're going to read over Lujan here. Over the years, our cases have established that the irreducible constitutional minimum of standing contains three elements. First, plaintiff must have suffered an injury in fact, an invasion of a legally protected interest, which is a concrete and particularized. B, actual or imminent, not conjectural or hypothetical. Second, there must be a causal connection between the injury and the conduct complained of. The injury has to be fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party, not before the court. Third, it must be likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. And it's Lujan versus Defenders of Wildlife, U.S. Supreme Court case from 1992. Moreover, the county court specifically found that the delay in this matter violated the defendant's constitutional right to due process, establishing as a threshold matter that plaintiffs suffered an injury in fact caused by the defendant's conduct. Given these facts, there is no plausible basis on which defendants can assert a standing defense. If defendants possess actual facts supporting threshold defense, such as standing, they should be required to present those facts immediately rather than preserving them as vague affirmative defenses. Conservation of judicial resources demand that fundamental jurisdictional challenge be brought promptly through appropriate motions rather than concealed within boilerplate defenses to be developed during months of discovery. Oh, I love that. That hits harder reading it this time around. Like, if you've got facts that destroy standing, bring that up immediately. Like, why are you wasting the court's resources?
Instead, the defense just wants to say, she doesn't have standing, and just leave it very blank, not bring any facts or argument. They just take my word for it, Your Honor.
Yeah, let's litigate this for the next 2 years while we assert that there's going to be a standing issue at some point.